Hi, I'm John Dalli. I'm here with my partner, Salvatore Marino, today. And unbelievably, January 1st of 2026 marks our 30th year in practice together. And we both thought it would be a good time to talk a little bit about what we've spent the last 20 years working on and devoting our practice to, and that's representing the victims of nursing home neglect and abuse. Sal, what's been the most rewarding aspect of litigating these cases over the past 20 years for you?
For me, John, in meeting these clients initially and seeing the look of disbelief and confusion on their faces when they describe what happened to their loved one, and litigating the cases for the amount of time that we do, and finally bringing some sense of justice to the families, that's the most rewarding for me. John, you find yourself in the courtroom litigating most of these matters. What do you find the most challenging when litigating these cases?
Sal, that's a really good question. When these cases first start, we have a huge challenge. First, we have to gather all the medical records, not only from the nursing home, but from any other facility that the resident might have been in. And we have to start to put a story together. Whether this person suffered a fall and fractured their hip, or suffered a bed sore that became infected that caused serious injury, we have a big job in trying to cull all of the information we need to prove a case. And I'll be honest with you, the nursing homes do not make it easy for us to get not only the records, but all the documentation we need to try to prove this case in court.
John, can you talk about what happens after we get the records and how the litigation proceeds from there?
So it's important that we depose the people who are really running the operation, the director of nursing, the administrator. And oftentimes we want to depose the owners because the owners are required under the public health law to use the money that they take in, mostly your tax dollars in the form of Medicaid and Medicare, for the benefit of the residents such that they all get the care that they require. Once depositions are completed, we can start to think about placing the case on the trial calendar. Unfortunately, because of the institutions we're dealing with and the insurance companies that insure them, we have to basically get to trial before a case is going to get resolved in many cases. Sometimes we can get a case resolved a little bit quicker, but the nursing homes and their insurance companies, they want to hold on to their money as long as they can. Sal, can you talk a little bit about what happens once the case is resolved, whether it's by settlement or verdict? What's the difference between nursing home cases and other types of negligence cases, like trip and fall cases or auto cases, in terms of a complete resolution?
Well, in these cases, often the clients or the resident that's been injured in the nursing home has passed away. So when that happens, you're not settling the case with the individual person that was injured. That person needs an estate formed. And in order to get an estate formed, we have to go to the surrogate's court. And the surrogate court involvement is its own process altogether. So initially, we have to form an estate to prosecute the case. And at the conclusion, we need to ask the court for permission to resolve it. You know, John, we have a unique practice. We have a surrogates practice and a negligence practice all rolled up in one.
No, it's so true. If there's any advice I could give to the folks out there, if you need a lawyer in this space, it's very important that you hire somebody who's got experience, not only in litigating the case, but also in all the other aspects of these lawsuits. It's truly a niche practice. And while there are many lawyers who can do it, you want to make sure that the one you choose has the experience and also has the knowledge to carry the case through the end.